Yes.
My lady, I believe one of the greatest challenges that the judiciary has is, I believe, inadequate staff in the sense clock, and I believe if I'm appointed, with all due respect, if I'm appointed to the bench.
So what are you going to do to deal with the backlog?
My lady, I will exercise, if appointed as a judge, I'll exercise my duties with utmost professionalism, with utmost efficiency, with utmost effectiveness to try and clear the backlog, my lady. I'll help reduce the backlog so that there's a faster dispensation of justice, my lady, if appointed.
We just want to know how you organize, because
yes, my lady,
it's not just doing the work, but it requires some organization to deal with that backlog.
Yes, my lady, thank you for that. I will ensure that if appointed as a judge, whatever station I'm allocated, I'll ensure that there's effectiveness amongst the judicial officers and judicial staff, in the sense that court starts on time and that files are dealt with properly and effectively, so that we don't have situations where files are missing or files are not placed before the judicial officers.
Very well.
Yes, my lady.
Happy with that.
Thank
Justice Murima, you take the next set of questions.
Thank you, Honorable CJ and Wakili, once again. Welcome.
Thank you, my lord.
You are intended to join the High Court, and my prayer is that you make it, so that you become part of it. And you'll be venturing into the arena of judgecraft. That is the totality of how you handle a matter from inception to the end, how you conduct it as the presiding officer of a court, judgecraft generally. Now, take it that you have been successful. You have gone for the ceremony at State House, the colorful ceremony, and you have been released, go ye into the temples of justice. Day one, you are seated as a judge, and the matter comes up, and the opening submissions by counsel is that this is a matter which involves conflicting decisions of by the Court of Appeal. Now, without going further, what areas of law, maybe an area or two of law, which can readily come to your mind where we have such a scenario? An area of law where there are conflicting decisions at the Court of Appeal. Don't worry if they were settled by the Supreme Court or not, just at High Court, at Court of Appeal. Which areas would readily come to your mind?
What areas would come to mind? Because I believe when it comes to the Court of Appeal, basically we'd be dealing with the cases that fall within the ambit of the Court of Appeal. And the cases that fall within the ambit of the Court of Appeal are cases of appeal from the High Court.
No, you did not understand.
I didn't get you.
You don't understand.
Yes, my lord.
You are handling a matter in the High Court.
Yes.
And the submission is that this is a matter which involves an area of law which has conflicting decisions from the Court of Appeal. Now, in your general practice,
very well. Okay.
Which areas could those be? Maybe one area or two areas where the Court of Appeal has given different position on the same thing.
Perhaps family law. Which
particular subject or area?
Succession.
Yes, which subject? Because family law is wide.
Where there would be conflict.
Yeah, where there is something maybe which you have encountered in practice, because it's, if you are in private practice, that is something which you must have at least come across, at least one area where the Court of Appeal, you know that the Court of Appeal has rendered itself on two positions.
Perhaps there would be, when it comes to validation of a will, different judges would probably have like different decisions when it comes to validation of a will. Or perhaps under the Law of Succession Act, or the interpretation of a dependent, perhaps.
Okay.
Yes.
You may need to take some bit of time. You look into that
Very
because
well.
you need to be ready when you come over. When I receive you, those are some of the things you will be facing from day one. So you may need to look at them so that you are on top gear.
Thank you, my
Now,
lord.
have you heard about this protocol called Maputo Protocol?
I have, my lord. I have, my lord, but
You
I
have.
might not remember the details right now.
Okay, so
Yes,
you may
my
not
lord.
even know
Yes.
what it stands for and all that.
As of now, I can't, my
Okay.
lord, remember.
Thank you, and I wish you the very best.
Thank you, Honorable
you.
Attorney General.
Yes, good morning again.
Good morning, Commissioner.
As a High Court judge, you will be dealing with applications for review and revision. Please tell us the differences between review and revision.
Now, review falls under the ambit where a decision has been made by a judge or a judicial officer, and an applicant files an application seeking to have the orders that are made reviewed. Basically, if there's reason for, if there's for one, if there's an apparent error on the record, and two, if there's new evidence that needs to come to the court's attention. Revision would be basically just seeking a revision of the order that has been made by the court.
What is the difference between review and revision?
Essentially, an application for review ought to go before the same judge who's had it, the same judicial officer who had the application. And revision would generally go before any judicial officer.
So what is the purpose for revision?
The purpose for revision would be in instances where there's a miscarriage of justice, in my view, and the applicant feels that perhaps an essential point was not tackled and ought to be reviewed or revised, rather.
Who can initiate a revision?
An aggrieved party, an applicant, an aggrieved party, or any party really to the suit, but essentially an aggrieved party. Before a party seeks revision or review, there'd be that aspect of dissatisfaction, so to speak.
Article 165, with regard to the jurisdiction of the court, provides that the High Court has supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising judicial or quasi-judicial function, but not over a superior court. Further provides that for the purpose of Clause 6, the High Court may call for the record of any proceedings before any subordinate court or person, body, or authority referred to in Clause 6, and may make any order or give any direction it considers appropriate to ensure the fair administration of justice. So when invoking this provision, what would the High Court be doing?
Your Honor, can I look at the, am I allowed to read it? That is Article 160.
165, 6 and 7.
If you can just look at it. My interpretation of this particular article, the subsections, is that the High Court, as it says, it has supervisory jurisdiction over.
Let me ask you directly,
Okay,
will
very
it be review or revision?
Revision, Your Honor.
Thank you, Honorable Chair. Is it Ms. Agutu or Mrs. Agutu?
Ms. Agutu, my lady.
Agutu. 29 years surely is not a short period, and I'm sure you're a general practitioner, isn't it?
Yes, I am, my lady.
Now let's move to the area of land law.
Thank you.
And you're aware that, of course, the law provides that if a person, say you have a purchaser's interest on land, you can file a caution
Yes.
in order to prevent the owner of the land, who has sold you the land, from disposing of it. Let's assume that an old man who wants to divide land and give it to his children comes to you and says, I've done a search at the lands office and I've discovered that there is a caution. I'd like advice on how we can remove this caution. How would you advise that old man?
Essentially, I would tell the old man that he can make an application to a registrar for the caution to be lifted. The initial step, he can make an application to the registrar for the caution to be lifted. I can assist him in filling the forms and submitting. I can submit on his behalf or advise him how he can go about it. And I'll further advise him that in the event that the registrar refuses to lift the caution, then he has the liberty of seeking the court's intervention. He can seek the court's intervention, seeking legal redress to have the caution removed.
So those are two ways that
Yes.
you've given me in which a caution can be removed.
Yes.
A third one? I'm looking for a third one.
A third one, my lady, would perhaps be a situation where once he has established who has placed the caution, and he probably has communication with the person who placed the caution, the person who placed the caution, and the old man, my client, would perhaps go to the registrar and have the caution lifted by consent. They can always agree to have it lifted by consent.
That's correct. That's
Thank
very
you.
correct. That the cautioner can, on his own, even on his own motion, remove the caution.
Thank you.
So if a caution is filed and it's a wrongful caution, are there consequences to filing of wrongful cautions? And if so, what penalties?
Yes, if my assumption is that if a caution is filed and it's a wrongful caution, in the sense that it's not justified,
Yes, correct.
the registrar has once the registrar is able to establish that the caution is wrongfully filed, he has the liberty to actually lift the caution, and then to the next step. My lady, I believe the culprit, let's use the word culprit, can be charged in a court of law. That's my... for giving wrongful information.
I'm not so sure about that, but
Very well, my lady.
look at the provisions
Thank
of
you.
the law as regards the consequences of filing a wrongful caution. Thank you.
Thank you, my lady.
Thank you. Council, I have one or two issues we want to discuss with you. Sometimes we have jurisdictional conflicts between the High Court and the Environment and Land Court, particularly where there is land and other matters that are involved. Is there a test that has been developed by the courts to resolve that those sort of conflicts, and what are the key principles?
Wow. Thank you, Commissioner. Right now, I might not quite recall the test, but this is my take, Commissioner, is that the High Court has no jurisdiction over matters that are essentially supposed to be dealt with by Environment and Land Court and the Employment and Labor Relations Court. My take is that...
Can I help you?
Yes, ma'am.
So there is the predominant test, predominant issue test.
Yes.
So that sometimes you have a jurisdictional conflict between matters that ought to be purely for ELC or matters that are for the High Court, say commercial. Now, suppose it is an issue about a charged land.
Yes.
What would be the appropriate forum to have that resolved? Will it be at the ELC or the High Court?
High Court. It would be at the ELC.
And why not in the High Court?
It would be at the ELC because a charge basically involves land, in the sense that a charged property involves a piece of land. So essentially, the land being the subject matter, it ought to be at the ELC court and not at the High Court.
But the land was used in a transaction.
Yes.
To advance money to a party. Isn't that a commercial transaction?
Yes.
So then, how do you resolve that? That's what I wanted to ask. Because these are disputes that ordinarily are brought, and they are.
Yeah,
those are the issues that are raised.
Judge.
Yes.
Yeah, there's the commercial aspect, considering the fact that it involves transaction, commercial money, and there's land. But essentially, the overriding subject matter is land. And as a presiding officer, I would probably just give directions that the matter be directed to an ELC court within the station.
Okay, but can a High Court can a High Court refer a matter from the High Court to the Land Court? Would it have jurisdiction? If you read Article 165 and then you read you have your Constitution.
Yes, I do. I believe it can give directions, Commissioner, considering the fact that the High Court is barred. It has no jurisdiction to preside over matters that essentially ought to go before an ELC court. I believe it can give directions.
So if it does not have jurisdiction, can it have then power to transfer?
Well, when it comes to transfer of a suit, essentially the process is it's essentially the applicant or the plaintiff ideally ought to file an application seeking for a transfer of the suit to the appropriate court. Essentially, that's what the presiding officer will merely give directions, direct the applicant to move the court appropriately, and the applicant, let's refer to the party concerned as the applicant, will file an application seeking transfer of the suit to an appropriate court.
Okay. All right. Thank you.
Thank you.
Good morning once again.
Good morning, Commissioner.
So I'm looking at your profile and even your CV. You've majorly been in practice.
Yes, Commissioner.
Which is the highest court you've practiced in?
Which is the highest court?
Yes.
I have been up to the Court of Appeal.
You've not appeared before the Supreme Court?
No, Your Honor.
Okay. How big is your practice?
Big. I have 2 branches. Mm-hmm. I have a branch in Nairobi, and I have another one in Ongata Rongai. I have staff of...
Ongata Rongai is?
Ongata Rongai, Kajiado County.
Okay.
Yes.
Mm-hmm.
Commissioner.
How many associates do you have? How many partners?
I have only 2 associates.
Mm-hmm.
The sole managing partner.
Okay.
Yes.
Now, do you engage in CUC or Bar Bench? Are you a member? Either in Kajiado or Nairobi?
I'm not a member of the CUC, the bench, but I was recently appointed as part of the committee that I'm the like LSK representative within the Integrity Committee, Kajiado. That's the role I play as at now.
Okay.
Yes.
You've heard of the acronym STAG.
Yes.
What is it?
If you could just spell it for me. ST.
AJ. STAJ. What is it in full?
I have, Yona. I'm trying to recall. I have.
Okay, even if you don't know the name, what it stands for in full, what is it as a document?
It basically, let me give a shot at it. I have read about it, Yona. I don't know, it's just escaping my mind. But it basically deals with alternative dispute resolution, alternative forms of dispute resolution.
It's not the only thing that is covered in STAG. Maybe you will need to look at it to appraise yourself of it.
Thank you.
Okay, lastly from me, imagine you're successful and you're appointed as a judge, and your first posting is to the family division.
Yes, Your Honor.
So you're given your docket. You have quite a number of succession cases, say 2,000. Half of them are pending determination of objections and protests. And they're quite old, let's say about 3 years old, or are getting to their 3rd birthday. How will you go about handling those with a view to expediting them?
I would have them listed for mention, and I would try and engage the parties and seek whether there's a possibility of the parties engaging in mediation, because succession matters really take long in court. In situations where the parties are able to agree so that they're able to withdraw the protests and they're able to have the matters dispensed with.
Explore ADR?
Yes, I would explore. That would be my first step. I would try and explore ADR. I would have them all mentioned. Just mention the way matters are mentioned for dismissal
all the
or for directions.
Cases.
Pardon, Your Honor?
All the 2,000 cases, mention them.
I could have them done in a period of time. I could do that. I could do that.
So you will explore ADR.
Yes.
You will dismiss.
Yes.
Or rather, let me not mislead you. What will you do concerning the dormant ones?
Yes, I would have them all mentioned, and then I would for the parties that make appearances, because what I've noted, Your Honor, with the succession matters is the instances where parties don't even make appearances. The same way dismissals come up. So in instances where there are no appearances, I would actually dismiss them, especially those that have been pending for long, because I've realized when there are dismissals, parties actually wake up. They wake up and they go back to court and seek against them.
A succession cause.
I would first, for the parties who make appearances, I would ask whether they would explore ADR. For parties who don't make appearances, because, Your Honor, with all due respect, I've realized there are instances where parties don't make appearances.
That's true.
I would actually dismiss them in the sense that so that they wake up.
And
so
what law will you be dismissing them?
I would dismiss okay, let's put it this way. I would dismiss the protest and the applications for objection. Yes, if there's no appearance, I would dismiss the applications for objection, and I would then list the matters for directions after that for the matters to proceed.
Okay.
Yes.
Thank you.
Thank you.
Good morning once again, Council.
Good morning, Commissioner.
If you need a water break, you are allowed to take the water.
Yes, thank you. Thank you. Thank you, Commissioner.
Okay, I've gone through your sample writings. You shared with us 5 of them. 4 are submissions before the Chief Magistrate Court and 1 submission before the High Court in an adoption matter. I would just want at an opportune time for you to tell us why, if you say you practice up to the Court of Appeal, you just attached submissions of from the Chief Magistrate Court. So your writings demonstrate solid command of issue identification and legal analysis. You show good ability to relate facts to applicable legal principle, frame issues clearly, and present coherent, well-tempered arguments, and the tone is professional. However, in one of the cases, that's the Raj Ushanga House Limited, you did not make any reference to decided cases. And you, before us, you want us to go to, you want us to consider you for the position of the High Court, a High Court judge, yet you've not made any reference to a decided case. And number 2, in the children matter,
Yes.
you did not initialize the names of the child. So you just indicated the names as, and yet you're not required to do that under the Children Act. So maybe you can just explain to the Commission how why you failed to submit your documents from superior courts, and the issue of not initializing the names of the child, and lastly the issue of making reference to precedent.
Thank you, Madam Commissioner. Now, as regards my written submissions for Rajushanga case, Madam Commissioner, I did not include any authorities or case law or precedents because I was of the opinion that the plaintiff had the evidence that was tendered in court. What happened is that both parties, the plaintiff and the defendant, adopted their pleadings. So both sets of pleadings were adopted. And then the plaintiff was able to get directives that an inspector from a surveyor from the Survey of Kenya does an inspection on the property. And to ascertain the location of the property and whether indeed, in a nutshell, whether the property indeed belongs to the plaintiff. And the surveyor prepared a report. The surveyor visited the property, surveyed the property, and prepared a report. And Madam Commissioner, the evidence that was tendered by the surveyor was not rebutted by the defendant in any way. I felt that the plaintiff had met the threshold just by adopting his pleadings and the evidence of the expert witness being the surveyor. And
but among the orders you are seeking were permanent injunction and declaratory. So you didn't feel it was wise for you to make reference to any decided case on when to issue permanent injunction and declaratory orders? There are decided cases around those 2 issues.
Yes.
Okay.
Madam Commissioner, it's just that I felt that the report that was tendered in court by the surveyor was so damning. It by itself was sufficient.
Okay.
Yes.
And the other 2 issues?
Yes.
The other courts, if you practice before other courts, how come you only brought matters before from the Chief Magistrate Court, and the issue of not initializing the names of the child in the adoption matter?
Very well, Madam Commissioner. Maybe I can start with the initialing the child. To be honest, in that particular case, the adoption case, what was happening is that for adoption matters in that particular case, even a perusal of the proceedings, the child was actually being referred to. You see, there's the name that the child gets from the adoption, from the children's home, and then there's the name that is given by the intended adoptive parent. And for the pleadings for the entire file, actually, to be honest,
you're required not to use the child's name.
I appreciate that.
Okay. And can a High Court, my last question is, can a High Court issue structural interdicts in a civil and political rights claim?
My lady, Madam Commissioner, I might not be able to respond to that as
Okay,
of now. Thank you.
Yeah, all the best.
Thank
Thank you, Chair.
Thank you very much. I'd like to discuss with you a little bit about your writing skills.
Thank you.
You would agree with me that judgments ought to be impartial, objective, even-handed, and unemotional. Would you agree with me?
Yes, my lady.
Okay. And I've been looking at your sample writings, and you know, the use of an exclamation mark is a very strong emotion. Exclamation mark means you are either surprised or full of joy or forceful. And if you use it too much, people say that if you use exclamation marks too often in your writings, it can be considered unprofessional and even like shouting. So coming to your writings, if you look at your written submissions in the divorce cause E017 of 2023, you have used exclamation marks 33 times, in fact in almost every paragraph. And in another sample writing you've given to us, tribunal case number 215 in 2021 regarding a car wash, it's a 7-page written submission document. You have used exclamation marks 22 times, including when you are seeking prayers from the court. How are we to know then, if we take you as a judge, that you will not be emotionally entangled and your judgments will be full of exclamation marks? And we will then be asked as the JSC to have a look at you because you are very emotional. So I'm concerned about this, and is there a reason why you use exclamation marks excessively? Because you do. That's my question.
Thank you, my lady. First and foremost, I'll take this opportunity to apologize for that. I believe this is a profession that entails a lot of learning, continuous learning, and I believe I'll probably take it as a point to use abbreviations properly, as in I apologize for that. And then secondly, my lady, when I do my work, actually, I don't include my emotions. I'm very professional. But I believe in the instances for those particular cases, the divorce matter and the tribunal matter, I believe, for one, I apologize for that. But secondly, it's because, especially the divorce matter was very acrimonious between the parties, and let's just say it was very acrimonious, and the parties were really, let's put it was a messy divorce. And I felt, probably wrongly so, my lady, that by using the exclamation marks, I would be emphasizing certain points because of the fact that I really needed to emphasize that my client had met the threshold and had been able to fulfill the requirements and basically just met the threshold. And also because of the character of the respondent, the respondent gave a totally different picture, and the petitioner gave a totally different picture. So I probably, in a bid to just emphasize that this is so wrong, this is not right, I inappropriately used the exclamation mark. But it's because the two matters were very acrimonious, and in my thinking, maybe wrongly so, my lady, I thought I was emphasizing points by using that. But I'm not emotional, my lady, I'm very professional. I apologize for that.
Thank you. I don't have another question. Thank you.
Thank you, my lady.
Thank you very much, Honorable Chair, and welcome again, Wakili.
Thank you.
Now, Article 201 of the Constitution emphasizes prudent and responsible use of public resources. You don't need to refer. So what does this mean in the day-to-day work of a High Court judge? Can I repeat?
Yes.
I'm saying in general, Article 201 of the Constitution emphasizes on prudent and responsible use of public resources. What does this mean in the day-to-day work of a judge, of a High Court judge?
Thank you, Commissioner. My take is that, for one, a judge ought to use time properly, time being a resource, in the sense that a judge ought not to adjourn matters. Okay, parties will come and seek adjournments. They'll come and seek adjournments, but a judge ought to take cognizance of the fact that matters ought to be dispensed with in the fastest time possible. So a judge will try not to agree to adjournments unless for very good reasons. That's one. So there's time. There's also the resource of, the stationery and everything. Ideally, a judge ought to ensure that proceedings, that matters proceed fast, and basically that matters are heard, and the judge ought not to have too many court appearances, so that at least the judge doesn't use too much stationery and too much of the court's time. Also, there's the judge part and there's also the applicant's part. So time is one resource. That's one. And time also comes in when it comes to court appearances. The judge also ought to make court appearances in time, in the sense that, for one, the judge ought to start court early and, proceed with as many matters as possible, so that there is no also time wastage for the parties. So time is one major resource that the judge ought to really take into consideration. That's one. And then when it comes to the paperwork, the resources that are used, so that if there are not too many unnecessary court appearances, at least the judiciary is not is not forced to use more resources for stationery and stuff. My take.
Okay. Now, what does Chapter 6 of the Constitution demand of a judge beyond absence of corruption?
Yes.
And how will you also, or tell us also how you will apply the principles of Article 232 in your work as a High Court judge?
Very well. Thank you, Commissioner. Basically, I would, the said articles require that a judge is impartial when hearing matters, so that there's transparency, there's impartiality. The said article also requires that there's integrity, so that when I'm hearing matters, I will do so without any fear, without any favorism, without any prejudice. I'll do so objectively. The said articles also require that there's accountability, so that if I'm hearing matters, I need to also be able to give reasons for the decisions I'm making, as in analyze, hear matters impartially for one, analyze the evidence that has been brought before me, and give sound judgment that does not show any, that gives sound reasoning. I'm thinking of, yes, so transparency, accountability, impartiality, integrity, good use of resources, time, that, and also ensuring that matters are heard expeditiously.
Okay,
yes, so
we
that
can live
yes.
with those ones so that you
Thank
don't
you.
repeat. Now, could you also share with us an instance where integrity was put to test, and how did you go about it?
Thank you, Commissioner. I've had situations, honestly. I've had situations where I'll probably just put it, because it's instances that come once in a while, where situations where you're representing a party, and a party will ask, can we talk to the judge? Can we talk to the, can we talk to the judge or talk to the judicial officers? I've had those kind of scenarios where a party will want us to, talk to the judge, and I would tell them that I do not do that. We cannot do that. We cannot do. So that one is usually quite rampant. There's not rampant, let's just say instances where parties would ask, can we talk to the judge? And you tell them, we cannot do that. So there are instances where my integrity has been put to test, because you'll find parties will say that, oh, you're scared, you don't want to do this, and I'll be like, no, I cannot do that. And there are instances where I've actually even lost clients because of that. Yes.
Okay, thank you very much. I wish you all the best.
Thank you.
Thank you, Honorable CJ. Wakili, I have a few questions for you. Now, COVID-19 introduced very new ways of doing things in the workplace and all over the world. What risks do you think the judiciary faces in regards to this? And what would you do, or what would you propose to mitigate the risks in a way that does not compromise the delivery of services to citizens?
Now, COVID-19 brought about the virtual court session. I believe because of the COVID pandemic, the resultant effects were virtual court session, the virtual court session, and for one, it's been an effective means of dispensing with justice. But unfortunately, and with all due respect to this panel, unfortunately, it has also, for one, resulted in delays in certain instances, in the sense that you find in many cases there are matters that are continuously being mentioned. And this is vis-a-vis court appearances, because when we'd have court appearances, you'd have situations where lawyers make appearances in court. But with the virtual sessions, I've realized, and with all due respect to my lady, is that the instances where people don't just make appearances. One, so it's had its good side, because it's techno savvy and everything, but it seems to somewhat sometimes delay the quick finalization of cases. That's one. And secondly, also as regards the said virtual sessions, sometimes when it comes to like certain cases like land matters and everything, the feeling is that the parties sometimes are not really able to properly proceed with matters, in the sense that, you see, now you find a party sitting here next to his lawyer, and the opposing party, the opposing counsel is the other side, cross-examining and everything. And a party sitting here next to his lawyer, you can have situations where, because ideally when you're being cross-examined, there's need for you to give correct answers and, be truthful and everything, having sworn and everything. But sometimes there are situations where I think it also does something about the evidence, in the sense that with an advocate sitting there, an advocate can always just, give answers to the party.
Okay, so how would we mitigate that?
I'm thinking that for virtual sessions, probably we can have situations where there are cases that are probably strictly proceed physically.
Okay.
Physically. And also I'm thinking that maybe, and with all due respect to my lady, I'm also thinking that maybe it's high time. Yes, we had a classification of matters that are strictly virtual and matters that now will just proceed physically.
Okay.
So that, and this is because COVID has been contained. How
about the issue of, you're being cross-examined, you're seated next to your lawyer? How would you go about that?
Yes, and that's why I'm saying that it's brought about that, I'm trying to think of that compromises, the kind of evidence. We would probably have scenarios where there could be direction so that there are situations where the litigant is not supposed to sit next to not supposed to sit next to the advocate, to the lawyer. We can have situations where now parties sit at different physical locations, because I think it really compromises the evidence that is given.
Okay.
Sometimes.
All right. Finally, for me, how do you guard against undue influence or interference by stakeholders, or what we call stakeholder capture?
Come again.
How would you guard against undue influence from stakeholders or interference by stakeholders?
My take is this, probably. I would say that just don't give them audience. Just don't give them audience. You're saying undue interference from stakeholders.
Yes.
In the sense that if, say, political interference?
In judiciary, we have different stakeholders.
Yes. My take is that as a judge, I would probably just not give them audience. That's what's coming.
But you understand, we have stakeholders that we have to interact with and that we have to deal with.
You've said undue interference, undue influence.
Yes.
Okay, fine. There's the bit where I can politely just, okay, fine, you can give them audience, yes, and hear them out, and then just politely tell them that this is the position, that this is how we operate. We cannot do this. This is the boundary.
Okay.
You cannot cross this line. Yes.
All right. Thank you, and I wish you the best.
Thank you.
Yes, Judge. To be or aspirant.
Thank you. Thank you, Mr. Commissioner.
Well, our judges, do judges participate in public collections?
Public collections?
Yes.
No, they don't.
Harambe.
No, they don't, to the best of my knowledge.
Okay. No special circumstances?
I believe that maybe in instances when it comes to activities like church activities, perhaps like if you're a member of a church, there's that church activities, family activities, where there's need for family members to help a child go to school, or church activities where you're basically helping in a donation towards constructing a church, or in those levels. But when it comes to political arambes, when it comes to associations or situations that conflict with the position, I believe a judge is not is not allowed to do that. But when it's family, or when it's a church, situations where as a citizen you can help, then I believe a judge can contribute to that.
Do you participate in any social activities? Social,
I would say that the activities I participated, okay, the activities basically that I participate in mostly are just at home, up country, helping my family, my extended family, and also helping towards just the same things when it comes to like community affairs, like the church and the schools back at home, my village. That's what majorly I do.
Okay, thank you.
Thank you.
We also want to know, what is your world view? How do you view the world?
Wow. The world is a small village. It's a small world in the sense that, sometimes you feel that, how do I put this? It's a global village in the sense that there's the possibility of interacting and what's the word, with citizens from anywhere is so easy. It's become so, and I think with technology, it's become so easy to communicate. You know, the way you can send a tweet, and the President of the Republic of the United States can also tweet. So it's become such a small village. It's so easy to interact. Technology has made interaction so easy.
Okay. I think this brings us to the end of the interview. We've looked at your documents as well. I would request that you organize them better, yeah?
Thank you.
It looks like you went to look for them piece by piece
I'm
and
sorry.
came with them
I'm sorry.
in a scattered manner. Or this is your first interview you're doing in your life?
No, it's not my first interview, my lady. I had actually just assembled them, and I actually even pointed out to the officer who was receiving them that I have not laminated them, but I put them in categories of clearance certificates.
You don't have to laminate them, but yes, you put it nicely. You put your documents nicely, you know.
Sorry, my lady, I thought I did.
The person who brought is the one who even gave you this little thing to put them in.
My lady, I'm sorry for that. I'm sorry for that.
So organize that, because
Thank
as a judge, you'll be required to be very organized, especially with the documents. So this brings us to the end of this very interactive session with you, and we thank you. But before we release you, we always give a candidate an opportunity also to engage us. The floor is yours.
Okay, thank you, my lady. I just want to take this opportunity to thank all of you for allowing me once again to appear before you. This is actually my second appearance. Thank you so much, Asante. It's been an honor just doing this. Thank you.
Okay, on behalf of the commissioners, I take this opportunity to wish you all the best.
Thank you.
And you are now released. Have a nice day.
Thank you, my lady. Thank you. Thank you, everyone. Thank you.